Nigeria is once again at a crossroads, a nation dealing with issues of rising kidnappings, grieving families, and communities living in fear. In response, the Nigerian Senate has revived one of the most contentious ideas in our justice system, the death penalty for kidnappers. Supporters in the Senate call it necessary deterrent, a decisive blow to a criminal industry that has cost thousands of lives and billions in ransom. They argue that extraordinary crimes demand extraordinary punishment and that the state must show strength where terror thrives. But critics say otherwise. Human rights advocates warn that capital punishment has never been proven to stop crime and that a system struggling with wrongful convictions cannot be trusted with irreversible justice. The question whether execution solves the problem or simply shifts attention away from the deeper failures in policing, intelligence gathering, and prosecution. So, is the death penalty the bold step Nigeria needs, or a dangerous shortcut that risks justice, human rights, and our international obligations? This is Politics on Sunday, and I am Femi Akonde. Well, tonight we'll go beyond politics into the heart of the debate. My guest is a man who has spent his life at the intersection of law, justice, and human dignity. Professor Uchenna Emelonye, Professor of Human Rights and former United Nations envoy. He joins me from TVC News headquarters in Eko Atlantic, Lagos. Hello, sir. It's good to see you again. Hello, sir. It's good to see you again.
Good evening. Thank you for having me here.
Good evening. Let's get straight into it. You know, they say desperate times require desperate measures. Is this not what the Senate is trying to do? Because this insecurity, especially the rise in kidnappings recently, has become really like a very serious problem that, you know, appears to be overwhelming security agencies in Nigeria. So why fault the Senate's move?
Yes, I would agree with your preface that desperate issues requires desperate measures. But I would add a caveat that it must be desperate measures that are working or that could work. It's not just the desperate measure. And before I go into this conversation, I want to commiserate with every Nigerian that has experienced this trauma of kidnapping and the wave of kidnapping in the country. I want to also place on record that I am not holding brief for kidnappers and I'm not supporting kidnappers or criminality of whatever form. It might also interest you that I've also gone through that process indirectly. I have gone through that waiting moment because my elder brother was kidnapped and it was my responsibility to negotiate with the kidnappers. It was my responsibility and difficult responsibility to discuss ransom and deliver ransom to them after several hours of being on transit in the course of this delivery. The point is, I resonate with every Nigerian, I sympathize with every Nigerian, I commiserate with every Nigerian. However, I am saying that the approach that the Senate is adopting through death penalty is not effective. It's not empirically proven, and the comparison for countries where it is working is misleading because the comparators are not in the same jurisdiction with Nigeria. The comparators are not sharing the same challenges like Nigeria. So we cannot compare it works in China, why wouldn't it work in Nigeria? Or it works in the US, why not Nigeria? The important point is, in these countries, the level of surveillance is what is making it work. It is not punishment, it's prevention. So I want to advert the attention of the Senate that the approach, the route they are going, which is raising the punitive level, punitive threshold of adopting death penalty, it's not working. I can also give you an empirical evidence, which every Nigerian might know. We still have death penalty existing for armed robbery in Nigeria. But execution was only done maybe 9 years ago, in 2016, by Governor Oshimole, as he then was. He was the last Nigerian governor that signed a death warrant. Before that point, the second recent execution happened in 2013 by the same governor. So my point is, if death sentence, if execution is working, why are Nigerian governors not executing it, implementing it? Today we have over, according to the Correctional Service, as at 2024, we have over 3,503 inmates on death row. So why are we having this number on death row and having a very little execution, and at the same time looking at adopting death penalty as a measure to curb insecurity?
Get your point, but I get your point, Prof. I get your point, Prof. But like some Nigerians are saying, should it matter? Hello, Professor, can you hear me?
You can easily get a SIM card at the airport. That is wrong. Kidnappers today would use a phone and discuss ransom with victim families, and they are not caught during and after this incident. That's an institutional gap. Today, kidnappers boldly disclose where they are, yet they are not apprehended. So my approach is to say that the Senate's route of adopting that penalty, it's the list of the criteria or list of the priorities that are required. The major one is preventive measures. The level of proliferation of arms in the country should be addressed. The porous nature of our borders should be addressed. The cooperation between the NCC and the police should be addressed. The police level of investigation and interrogation should be strengthened, and not necessarily adopting death penalty, because in effect, we have death penalty in robbery, and governors are not executing. So if you look at the 3 last executions in the country, it happened between Plateau State, Enugu State, and Kaduna State. So what about other states?
Professor, can you hear me now, sir?
In principle, and my point to Senate is to say the intention is emotional. We are approaching it from a very sentimental point of view. Let's look at it from the point of what works and what has been working. In every crime, criminals are deterred more if they envision a likelihood of being caught than being punished.
Allow me to come in here.
Waiting to the point of the crime being committed before we respond. The approach of the entire nation should be to prevent and make sure that nobody is kidnapped, and not that allow people to be kidnapped and now want to punish people who are involved in it. So this is the point I want to clarify, and I wish this argument can be canvassed by the Senate and interrogated, and they will see from where I'm coming from, because, it will surprise people that we still have death penalty on armed robbery, and yet the level of execution is insignificant. It's insignificant. It's insignificant.
All right, Professor, can you hear me now? Yeah. And we are discussing, or we are revisiting, the Nigerian Senate's proposal to hand the death sentence to kidnappers. Well, the professor is saying that, this proposal contradicts Nigeria's international human rights commitments and, also undermines global normative standards. But, Prof, some Nigerians are saying that, should it matter when it comes to kidnappers who also take the lives of innocent citizens? They are also a threat to life in the country. Why should it now matter when a death sentence is pronounced on them?
I deliberately chose not to pitch my argument on normative grounds based on Nigeria's obligation internationally, because that would sound theoretical for an average Nigerian. And that is why I domiciled my argument on what works and what has been proven to work. In any case, Nigeria has signed the International Covenant on Civil and Political Rights, which has an optional protocol on the abolition of death penalty. In truth, Nigeria has not signed this optional protocol. So legally speaking, it is not bound by that provision. But however, there's been a moratorium in Nigeria that in the last 9 years, there's never been an execution. And just next year, it will be the 10th year. So Nigeria is making steps towards the abolitionist jurisdiction and joining the countries in the world where death penalty is no longer applicable. So that is the trajectory Nigeria is going. And we are at that point where we seem to be stepping backwards. But that is not the substratum of my argument. That is not the basis of my proposition. That is not the strength of my advocacy. The point that I want to say is the approach of the Senate in reintroducing death penalty is not a deterrent to criminality. What would deter criminals and kidnappers is not the likelihood of being executed. It is the likelihood of being caught. So prevention should be the watchword and not punishment. And if you recall, before we went on break, I also said the fact that the death penalty already exists in armed robbery in Nigeria. And very few states are adopting this. Even when they do adopt it, there's this restriction that is questionable, and which is the fact that inmates that come into inmates sentenced and moved to death row needs to be executed according to when they come in. But if you look at the last 3 executions, particularly the 2 that happened in Edo State, which is the most recent, the people executed were not the next in turn to be executed. So the question now becomes, what discretion did the governor apply to choose who to execute and who to execute? So that discretion is too much, particularly when it involves irreversible life. You all know very well the challenges of our justice system. We all know very well the level of investigation and the weight of confession, which are already induced in the justice system. Why do we need to rely on this ineffective approach when there are measures we can take to immediately prevent kidnapping? I just mentioned one, the issue that kidnappers could comfortably and confidently negotiate with a SIM card that is registered. The police and the NCC can adopt measures to track this. I also have a very important point, which I'm also canvassing to the Ministry of Justice, particularly, which is the legal advisor to the President, to the government, which relates to the powers under Section 3053C to F of the 1999 Constitution as amended. The government can declare a state of emergency, not the one that is declared verbally. There are conditions required in declaring state of emergency. Particularly, rights are not absolute. Human rights are not an inhibition to fighting terrorism. Human rights is an enabler. And because human rights are not absolute, there are some rights that can be derogated. The government can choose to derogate these rights. There are only criteria to derogate. The first one is that must be through an act of parliament. So the Parliament of Nigeria should know those rights that needs to be derogated to enable us fight terrorism. Secondly, the execution of that derogation should be time-bound. There should be a limit pronounced by the government within which this can be done. It must be non-discriminatory and it must be proportionate. So government can choose to limit rights, to fight and give the police excessive and lawful powers to address this. So this already...
Yes, Professor. We heard the former president, Muhammadu Buhari, also, saying, I'm not quoting him verbatim now, that, national security in some cases even supersedes or overrides the rule of law. But, we have seen President Bola Tinubu now declare a national emergency on security. Is this the way to go? Talking about recruiting more people into the police force, but, people are also talking about recruiting them when the institution itself is weak. The training facilities are obsolete. So it's like bringing them in to an already broken system.
The point I would add to the good work that the President has done through the declaration of this emergency is to come out with the rights that needs to be derogated, that needs to be limited to enable the police and the authorities fight this process. So it is not enough to declare a state of emergency. The next step is, having declared a state of emergency, there are 2 requirements, there are 2 reasons for that. The first is to fight to protect national security. Sorry.
Well, you know, Professor, you will also go ahead, Professor. You will also go ahead, Professor. You will also go ahead, Professor. Okay, well, Professor, I was going to ask you, you talked about some rights. We also saw some privileges withdrawn from VIPs. The president gave a directive that policemen attached to VIPs across the country should be recalled. They should all be recalled back to base and redistributed across the country to protect citizens and to also go to vulnerable areas that have become soft targets for these criminals and bandits. How effective, or what kind of impact do you expect this directive to have? Because it's not the first time we're seeing this kind of directive from a sitting president. And indeed, Inspector Generals of Police have also given this kind of directives, all to no effect.
I want to place on record my commendation to that initiative, which I will also narrow down to only providing a quantitative benefit. We need just more than the numbers. We need the quantity, we need the quality of the personnel. And this is where the state of emergency should give police lawful but excessive but lawful powers to do the unusual. So to do the unusual, we don't just need numbers. We need the mandate, we need the powers of arrest, we need the prosecution, we need the trial, we need the investigation, we need the surveillance that is required in the country. You know very well, the surveillance limits the right of privacy, but this is also the essence of fighting terrorism and insecurity anywhere in the world. So the state of emergency and the next step that I'm proposing, and which is the right thing to do, is to come out with the rights that need to be limited within this period to enable us to make a change. The one that has been done, which is recording the police, is good. It's only the quantitative value that it brings, which is the numbers. But beyond the numbers as well, we need also the qualitative component of that state of emergency, which is the powers of the police to do what they cannot do now. If you know the rhetorics that's involved in this act, the police will say, or the army will say, that they are limited because of respecting rights. They are limited because of the international obligations that Nigeria subscribed to. If these international obligations come against national security, the government, on grounds of protecting national security, which is the essence of government, can limit rights. But it needs to come out plain and public in terms of the rights it needs to limit, the period it needs to be done, the approach that should be adopted, and the fact that it must not be discriminatory and proportionate. So we have litanies of platforms and plethora of opportunities to make a change through the existing normative framework. And this is why I'm coming back to the Senate to say, whereas that approach is emotive, we need beyond sentimental response to kidnapping to look at what would work and what would make a difference.
So maybe it's also because, the government previously adopted an approach known as the non-kinetic approach. A lot of people say this is handling or treating the kidnappers with kid gloves, where these bandits, come ravage a whole community, and they tell us that, well, it's because they are deprived of certain privileges and rights, and that's why they have decided to vent their frustration on defenseless citizens. And people are saying that this non-kinetic approach is not working. It's time to go kinetic, to go all fronts. Let me use the word of Donald Trump. Guns are blazing against these bandits. Which of these methods would you rather adopt, the kinetic or the non-kinetic?
Security experts would know that both are mutually reinforcing. You can seldom use one without the other. So in every climb, the judgment call is for the security agencies to adopt what is necessary for the time being. But ultimately, I would not choose one for the other. And by the way, this is a purely security decision. But from the point where we sit, and I sit as a Nigerian, is to look at what is the result. What result is it are we saying? If national security, if human rights is an inhibition to achieving the results that national security officers are bound to achieve. The difference I'm saying today is to refer us to the grounds that human rights can be restricted. There are few human rights that are absolute, that cannot be restricted in any circumstance. For instance, torture, for instance, fair trial, and for instance, slavery. The rest can be restricted. So the government can choose to restrict, if that gives them the powers to address the situation.
Thank you. Well, thank you very much, Professor. I'm afraid that's all time will permit us to take. And apologies for the technical glitches that didn't allow us to enjoy this conversation. But well, that's all on the program today. You can see this episode again on TVC News YouTube channel. Thank you very much for watching.